Be ready. Start. Repugnancy between two statutes would arise if there is direct conflict between the two provisions and if the law made by Parliament and the law made by the state legislature occupy the same field. Stop. In the instant case, the State Act intended to eliminate private operators from the state in regard to contract carriages acquired under the existing permits, vehicles and ancillary property, and with a view to giving effect to a monopoly situation for the state undertaking made provision in section 20. Stop. The Parliamentary Act does not purport to make any provision in regard to acquisition of contract carriage permits which formed the dominant theme or the core of the State Act. Stop. Nor does it in section 73 and section 74 indicate as to who the applicant shall be while laying down how an application for a contract carriage permit shall be made and how such a permit shall be granted. Stop. Section 80 of the Parliamentary Act does contain a liberalized provision in the matter of grant of permits, but even then, there again, the ancillary provision contained in section 20 of the State Act to effectuate acquisition does not directly run counter to the 1988 provision. Stop. There does not thus appear to be any repugnancy between the two acts for invoking Article 254 of the Constitution. Stop. There is no repugnancy in the provisions of sections 14 and 20 of the Karnataka Contract Carriages (Acquisition) Act 1976 and sections 74 and 80 of the Motor Vehicles Act 1988. Stop. Hence, the provisions of Article 254 of the Constitution does not come into play. Stanza. Whenever repugnancy between the state and central legislation is alleged, what has to be first examined is whether the two legislations cover or relate to the same subject matter. Stop. The test for determining the same is to find out the dominant intention of the two legislations. Stop. If the dominant intention of the two legislations is different, they cover different subject matters. Stop. If the subject matters covered by the legislation are thus different, then merely because the two legislations refer to some allied or cognate subjects, they do not cover the same field. Stop. Mr. Riley, learned senior counsel for the petitioners, at the outset submitted that the appeal was preferred by the petitioners within the time stipulated under subsection (7) of section 7 of the Act. Stop. He submitted that merely because an amount equal to the amount of gratuity required to be deposited along with an appeal is not deposited at the time of filing of the appeal, it cannot be stated to have been filled on the date of deposit of the amount. Full stop. Over.